Welcome to Anatomy of a Will. In today's episode, we're exploring a topic that often feels like navigating a foreign country without a map: the actual structure of a last will and testament. This is the same topic we recently wrote about on our blog because we've noticed a pattern. Many families avoid estate planning not because they don't care, but because the language feels exclusionary. It feels overwhelming. We are going to break down the anatomy of a will, translating the essential jargon into plain English and explaining the 5 key clauses you need to understand. From a SafeSimpleSound perspective, we want to move you from a place of uncertainty to a place of capability. We often say that a will is just a set of instructions, but if you don't understand the language those instructions are written in, you can't be sure they'll lead your family to the destination you intend. So, let's take a deep breath, set aside the intimidation factor, and look at this document through the lens of simplicity and soundness. By the end of this episode, you'll have the vocabulary to have a truly productive conversation with your attorney and your family. Let's begin by establishing a foundation. When we look at estate planning through the SafeSimpleSound framework, we often see a simple problem: the language barrier. Stepping into the process of writing a will can feel like learning a new language. You're suddenly faced with terms like per stirps, codicil, or testamentary trust. It is very common to feel a sense of imposter syndrome when sitting across from an attorney. You might nod along, hoping you understand, but walking away unsure. Our goal today is to strip away that complexity. We want to apply the simple aspect of our framework to translate these concepts. First, let's talk about the people involved. In our practice, we see clients trip up on 3 specific terms: heirs, legatees, and devisees. Now, in casual conversation, we tend to use these interchangeably. We might say, "My son is my heir," but in the legal world and in the world of sound financial planning, precision matters. Heirs are the people who are legally entitled to inherit your property under your state's laws if you die without a will. Think of this as the default setting. Typically, this includes your spouse, children, parents, and siblings. A will can confirm these people as beneficiaries, or it can name different people entirely. But heir refers to that biological or legal default. Next, we have legatees. This is a specific term. A legatee is a person or organization you name in your will to receive your personal property. When we say personal property, we mean the movable things: cash, stocks, bonds, jewelry, your car, or that vintage watch collection. If you leave your vintage watch to your nephew, in the eyes of the law, he is a legatee. Finally, we have devisees. This sounds similar, but it applies specifically to real property, meaning real estate. If you leave the family lake house to your daughter, she is a devisee. Why does this matter? Why are we splitting hairs here? Because clear communication is a principle of the S3 framework. Using the right terms helps ensure your wishes are interpreted correctly. If you leave a devise of your car, it might create confusion because a car isn't real estate. Clearly identifying the who is the foundational first step. Now that we know the beneficiaries, let's talk about the manager. In a will, this is the executor, sometimes called a personal representative. If the will is the instruction manual, the executor is the person holding the wrench. They are responsible for locating the will, filing it with the probate court, paying off debts, and distributing the property. Drawing from our GFC background at SafeSimpleSound, we often see a common challenge here. Families frequently default to appointing the oldest child or the closest sibling out of a sense of obligation or tradition. However, the S3 framework suggests we look at this differently. We need to prioritize soundness over sentimentality. Being an executor is a job. It requires organization, impartiality, and a thick skin. Does your oldest child have the time to inventory assets? Do they have the emotional bandwidth to deal with creditors while grieving? From our perspective as financial planners, it is also vital that your executor has a degree of financial literacy. They will be handling accounts, tax filings, and property transfers. Through our practice, we've observed that when a family chooses an executor based on capability rather than birth order, the process is significantly smoother. It provides safety for the family relationships because the person in charge is actually equipped to handle the stress. This brings us to the heart of the document, the distribution clauses. This is where you actually say who gets what. Generally, these fall into three buckets. One, specific bequests. This is exactly what it sounds like. I give my 2022 Ford F-150 to my friend Sarah. It is identifiable and precise. Two, general bequests. This is usually a gift of value, like cash, that comes from the general pot of assets. I give $25,000 to my alma mater. Three, the residuary clause. Now please listen closely here. This is arguably the most important clause in the entire document. The residuary clause is the catch-all. It dictates who receives everything not listed in specific or general bequests. Imagine you list your house, your car, and some cash gifts, but you forgot to list a savings account you opened 10 years ago. Or perhaps you acquire a new asset after you write the will. Or maybe a beneficiary passes away before you do, causing a specific bequest to fail. Where do those assets go? Without a residuary clause, they fall into the intestacy bucket, meaning the state decides. The residuary clause acts as a safety net, ensuring every asset has a home, even the ones you forgot to mention. It creates a safe boundary around your estate. Now, understanding definitions is one thing. Seeing how they interact with real life is another. To illustrate this principle, let me share a hypothetical scenario that illustrates how these clauses interact with your broader financial picture. While this story is created for educational purposes, it demonstrates patterns we see when families apply S3 thinking, or fail to apply it, to their estate planning. Consider a fictional couple. Let's call them Robert and Linda Miller. They are in their late 60s, retired, and they want to do everything right. They want their legacy to be a blessing, not a burden. The Millers sit down with an attorney and write a will. In this will, they include a specific bequest. They state clearly, we leave our investment brokerage account to our son, James, to help him start his business. They also include a residuary clause that says all remaining assets shall go to our daughter, Emily. On paper, this looks simple. It looks sound. They have identified a specific asset for James and a catch-all for Emily. They leave the attorney's office feeling relieved and secure. However, 3 years prior to writing this will, Robert had opened that brokerage account. When he filled out the paperwork at the banker asked, "Do you want to name a beneficiary?" Robert, thinking quickly, named his wife, Linda. But let's say, for the sake of this educational example, that Linda passes away before Robert. And let's say Robert had previously named his brother as a secondary beneficiary on that account, just in case, thinking he would update it later. He never did, so Robert passes away. The family gathers. James expects to receive the brokerage account to start his business, as stated in the will. Here is where the contradiction arises. The will says the account goes to James. The brokerage account contract says it goes to Robert's brother. In the world of financial law, the beneficiary designation on the account acts as a contract that overrides the will. The bank is legally obligated to pay the funds to the brother, not James. While this story is fictional, it demonstrates a critical pattern we observe. You can write the most elegant, heartfelt will in the world, but if your assets aren't structured to support it, the will loses its power. In the Millers' case, the will was sound in its drafting, but the plan was not sound in its execution because the asset titling didn't match the legal instructions. From a SafeSimpleSound perspective, this hypothetical situation reveals why we cannot view a will in isolation. We established earlier that there are things a will cannot do. This is a crucial limitation to understand. Assets with beneficiary designations, things like life insurance, 401k, IRAs, and annuities, pass by operation of law. They bypass the will entirely. Joint tenancy. If you own a house as joint tenants with right of survivorship, it goes automatically to the other owner, regardless of what your will says. In our fictional scenario, Robert relied on the will to do a job it wasn't authorized to do. The will attempted to give away an asset that had already been given away via the beneficiary form. So how would we approach this through the SafeSimpleSound framework? If the Millers were working through our planning process, we would have engaged in what we call an asset alignment review. 1. Safe. We would review every single account to ensure the beneficiary designations match the current wishes. This provides safety against accidental disinheritance. 2. Simple. We would align the titling. If the goal is for James to get the account, we update the beneficiary form to James. Simple. Or We make the estate the beneficiary so the will can control it, though that has tax implications we'd discuss. 3. Sound. We ensure the will's residuary clause and specific bequests are supported by the actual legal structure of the assets. Whether you're facing this exact situation or simply wondering if your old 401k still lists an ex-spouse or a deceased parent as a beneficiary, this example shows why sound planning requires coordination. It's not just about writing the document, it's about preparing the assets to follow the instructions. Before we move to our closing, I want to address a question that comes up frequently in our digitally driven world. We do everything online now: banking, shopping, communicating. Naturally, people ask, can I just sign an electronic will? An electronic will is one that is written, signed, and witnessed electronically, rather than on paper with wet ink. Drawing from our commitment to the safe and sound pillars, we must offer a note of caution here. The validity of electronic wills is a rapidly evolving area of law. While a handful of states have enacted laws to permit them, most states still require a physical document signed in the physical presence of witnesses. Imagine the tortoise and the hare here. The digital will is the hare, fast, convenient, modern. The traditional wet ink will is the tortoise, slower, perhaps a bit old-fashioned. But in estate planning, speed is not the goal, validity is. If you execute an electronic will in a state that doesn't fully recognize it, or if the technology used doesn't meet strict legal standards, your family could end up in a prolonged legal battle simply to prove the will is real. Our S3 framework suggests that for something as critical as your last will and testament, sticking with the time-tested method is the safer bet. A properly executed physical document, drafted with the help of a qualified attorney, provides the stability we look for. It removes ambiguity. It protects your legacy from technicalities. As we wrap up today's episode, let's revisit the ground we've covered. We started with the idea that a will feels like a foreign language, but we've decoded that language together. 1, we defined the players: heirs, the default; legatees, personal property; and Devisees, real estate. 2, we defined the manager, the executor, who needs competence and financial literacy more than just a family title. 3, we looked at the instructions: specific bequests, general bequests, and that all-important residuary clause to catch anything left over. 4, we recognized the limitations. Through our hypothetical Miller family, we saw how beneficiary designations can override a will and why coordinating them is essential. 5, we prioritized safety by recommending caution with electronic wills until the legal landscape is more settled. This aligns with the principle of clarity. Navigating these details, from the clauses to the limitations, transforms a daunting task into an empowering act of planning. By understanding these essential building blocks, you are no longer just writing a will. You are creating a comprehensive strategy. You are protecting your loved ones from confusion and conflict. That is the definition of safe, simple, and sound. This episode draws from our recent blog post, Anatomy of a Will, the 5 key clauses you absolutely need to understand, which you can find at SafeSimpleSound.com. The written version creates a great visual reference for the terms we discussed today. Through our S3 approach development, we've created a process that doesn't just look at documents, but looks at how your entire financial life fits together. If today's insights regarding the conflict between wills and beneficiary designations resonate with your family's situation, we invite you to explore what financial planning could look like through our Safe, Simple, Sound practice. We can help ensure your financial life is well organized, with clear statements and properly titled assets, making your executor's job infinitely easier. But either way, whether you reach out to us or not, you are now equipped with a capability, a new vocabulary that will serve you well. You can walk into an attorney's office with confidence, knowing exactly who needs to be named and what questions to ask. Thank you for listening to the Safe, Simple, Sound podcast. Here's to planning with clarity, acting with confidence, and building a legacy that lasts.